Well, hello, everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm the Associate Director of Practice Groups with the Federalist Society. Today, we're excited to host this webinar on the FCC's proposal to regulate political ads using artificial intelligence. Our moderator today is Randy May. Randy is the founder and president of the Free State Foundation. Before that, Randy was a senior fellow and director of communications policy studies at the Progress and Freedom Foundation, a Washington, D.C.-based think tank. Prior to joining the foundation, he practiced communications, administrative, and regulatory law as a partner at major national law firms. Before that, May served as Assistant General Counsel and Associate General Counsel at the Federal Communications Commission. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. After our speakers give their presentations, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to get to as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Randy, thank you so much for joining us, and the floor is yours.
Thank you, Caroline, and thanks to the Federalist Society for hosting this forum, and thanks to our distinguished panelists, whom I'll introduce in just a moment, for participating. Without stealing any of the panelists' thunder, I want to introduce the program very briefly this way. The FCC has initiated a rulemaking proposing to require radio and TV broadcasters, as well as cable and satellite TV operators, to include a disclaimer on all political ads that contain content generated by artificial intelligence. In other words, such political ads would have to include an on-air announcement advising viewers that AI-generated content was used in the ads, whether they are candidate or issue ads. The broadcasters, cable, and satellite TV operators also would be required to include a notice in their FCC mandated online political files disclosing the ad's use of AI. The FCC notice states, quote, "We are not proposing to ban or otherwise restrict the use of AI-generated content in political ads. Rather, we are simply seeking to ensure that listeners and viewers are informed when political ads include such content so that the public can evaluate such ads for themselves," close quote. Now, for purposes of the proceeding, the FCC proposes to define AI-generated content this way, quote, "An image, audio, or video that has been generated using computational technology or other machine-based system that depicts an individual's appearance, speech, or conduct, or an event, circumstance, or situation, including in particular AI-generated voices that sound like human voices, and AI-generated actors that appear to be human actors." I have kind of a scratchy throat today, and that's me, not AI, that's doing that particular voice modification. So this definition is obviously an important one in assessing the practicality and effectiveness of the proposal. And the FCC proposes to require that all broadcasters airing political ads inquire whether those ads contain AI-generated content. Now I'm going to introduce today's distinguished panelists. Their resumes with their official positions and honors are all too long to really do here. So I'm going to suggest that you do refer to the web to get all the biographical information. And I'll just keep it short so we can get to the program. The first speaker today will be Brendan Carr. Brendan is a federal communications commissioner currently and has been for some time. Next, we're going to hear from Chris Lewis. Chris is president and CEO of Public Knowledge. And then finally, we're going to hear from Bradley Smith. Brad is a former Federal Election Commission chairman and professor of law at Capital University Law School. Now, I've asked each of the panelists to limit their initial remarks to no more than 8 minutes, because after the initial go-round, I'll give each of the panelists an opportunity to react to what's been said by the others. We'll get a good back and forth discussion going regarding the pros and cons of the FCC's proposal. And as Caroline mentioned, we'll save some time for questions from the audience. So keep that in mind as you're listening. One key question, perhaps Brendan Carr can answer during his initial remarks: does the FCC still intend to adopt these rules as the chairwoman earlier said a few months ago, before the November election? Of course, millions of votes already have been cast, and more are being cast every day. So with that, I'm going to turn the floor over to Brendan Carr for his initial remarks, and then we'll just go around. Brendan, the floor is yours.
Yeah, thanks so much, Randy, and thanks to the Federalist Society for hosting this good discussion. Look forward to the back and forth. I think this is one where, I think we'll have some reasonable, robust debate, and I look forward to that. I guess I'll start in the interest of common ground. Where do I assume or hope that we have some agreement? And one is sort of the emergence of AI as a potentially significant, almost generational style change across all sorts of different industries, from politics to business. You have a lot of people out there looking at fundamental transitions like the internet, like mobile internet, and then now AI as sort of a potentially sort of third massively disrupting force. I think there's probably a lot of agreement on that. The question is what to do about it. My general approach to sort of regulation of AI, and then I'll drill down to my specific view on this particular proposal, is I think we have to find the middle bowl of porridge, meaning I don't think that we should go with a total sort of fundamentalist libertarian approach to the regulation of AI. But at the same time, I think we can go way too far in terms of heavy-handed regulation before we've seen how the technology can play out. And that heavy-handed regulation could either tilt the playing field in favor of sort of established incumbents or the most established in an emerging field, which I think would be detrimental in the long run, or otherwise sort of suppress new and beneficial innovation. So just like, at least from my perspective, in the 1990s, the federal government got it right with respect to the internet itself, which is to make sure it was lightly regulated. We derived a lot of benefits from that. That's sort of the model that I would use here as well. Turning to the specifics here, there's also no question that we're seeing an increasing use of AI in political advertisements, but it runs the gamut. It runs the gamut from using ChatGPT style text services to help generate scripts, to sort of modern versions of Photoshop type video editing. Sort of AI generated is a very big umbrella term. I think that's sort of some of the concerns that I have that we'll get into. With respect to this specific proposal, I have a lot of concerns. One is sort of the origin of this particular proposal. If you look to the Federal Election Commission, there's been a proceeding started there a while ago to try to impose new regulations on the use of AI in political advertisements. The goal was to do it before this year's election. The DNC itself filed comments in that FEC proceeding in support of it. And there was a lot of press reports that were coming out around then that said, and I quoted some of this in my separate statements, that the DNC and Democrats generally were concerned about falling behind Republicans in the use of AI in the run to this year's election. And so, part of my concern is, the motivation for starting here. Is it sort of a true concern about, harms across the board from AI, or are there more sort of partisan concerns at play here? And then the FCC took up this proposal and issued its own NPRM that sort of has echoes of that DNC-backed initiative before the FEC. And at its core, it's about imposing new government regulations on political speech that uses AI. And at least initially, as you indicated, the press releases were showing that the FCC wanted to move this before this fall's election. I think if you look at the clock at this point and how long it took the FCC to go through our internal procedures to vote this, including, I guess, how long it took me to cast my final vote on this, I don't see a path forward at this point to the FCC adopting rules or making them effective before this election. And I think that's a good thing, because if we're going to adopt rules here, I think we should do it in a considered manner, not a rushed manner. And when I say we, I mean the government writ large, because my position is that the FCC itself both doesn't have the statutory authority or the expertise to engage in this regulation of political speech. Now, there are certainly some areas where the FCC has been given authority by Congress to regulate. So, for instance, the political file that broadcasters use. And the FCC has pointed to those as reasons why it has sort of relatively sweeping authority to impose this disclosure requirement on the use of AI. But I read those authorities as cutting the opposite way, which is to say they're sort of isolated pinprick, sort of narrow grants of authority that confirm that the FCC's authority here is very narrow and limited. They're not sort of sweeping provisions that give the FCC a general mandate to regulate political speech. Another argument that I've heard is that, what's the big deal? This is merely a disclosure regime. You just have to say if, in fact, you've used AI-generated content. How can you possibly oppose transparency? It's not a substantive regulatory regime. But to that argument, I would say this. One, it's not so straightforward. For instance, the FCC seeks comment on having what it describes as credible third parties be able to sort of effectively fact check whether AI was used or not. I think we've seen sort of a cottage industry of these sort of, in my own personal view, sort of activist fact checkers that I think it makes it sort of ripe for abuse, that political actors on the left or right that don't like an ad can start filing complaints about it. So I think it's sort of an open invitation for abuse in the system there. Second, I think that there's an issue with the failure to create a level playing field. So even if the FCC were successful, you would now have this disclosure regime on ads that run on broadcast TV, but you'd have the exact same ad or a similar ad running on the internet, and it wouldn't have the disclosure because the FCC doesn't regulate there. And what kind of impact does that have on viewers, on voters? Do they assume the one without the disclosure must be real and not AI? I think they're sort of ripe for confusion there. But my most fundamental concern really goes to legal authority. If you look sort of buried in the FCC's decision, in part, I would say because we don't have a lot of authority, the FCC's decision here breathes new life into these sort of 1960s policy statements that expressly stand for the proposition that the FCC's authority over broadcast licenses includes the ability to take action, revoke licenses, if broadcasters aren't doing enough to police misinformation, deceptive information that's aired on their broadcast stations. And I think the FCC's decision, 50 years later, or I can't do math, whatever that is, back to the 1960s, to breathe new life into those sort of long dead precedents that effectively the FCC should become the speech police going forward and taking actions on broadcasters whenever a majority at the FCC thinks that there's something that's been deceptively broadcast. That's sort of crossing a Rubicon that we haven't done in a very, very long time. And that's something that, again, I think we probably should have left those precedents where they were, but this is a commission that's decided to breathe new life into them. And so again, the idea it's just disclosure, okay, I can sort of understand that. But again, to get there, there's a very sweeping new claim of authority. So other than that, look, I oppose it, but I'm also not alone. You can look a lot at some civil libertarian groups, some free speech groups that are in agreement with me. If you look at the record itself, you've got various groups, including, I believe, the ACLU, FIRE, which is a free speech group, and other sort of organizations that have expressed concern about the sweeping nature of these and sort of the impact on First Amendment and free speech rights. So with that, I want to close my filibuster and let others tell the rest of the story.
Well, you were right on time, so that doesn't qualify as a filibuster. I will say probably the only one here that can remember the 1960s when I look at you young guys there. But and what Brendan said about the FCC's policies then certainly had a ring of truth as I remember it. But next, I want to hear from Chris Lewis, and I don't think he'll agree with all that Brendan says. In fact, I suspect not. That's why I invited him. And I'll just say this with respect to Chris. He knows I invite him to speak a lot when I have the opportunity, and I do it because he's a very articulate exponent of the positions he holds, and always does it in a respectful but effective way. So, Chris, I'm happy to have you here again, and you've got 8 minutes. Take it away.
Thanks, Randy. You're raising expectations for me, but I will try to meet them. I appreciate you and the Federalist Society inviting me to participate and be on with Commissioner Carr, who I know well from our filings at the FCC, and to meet Commissioner Smith for the first time. If folks don't know public knowledge, we're a nonprofit, nonpartisan digital rights organization working in tech policy, including at a lot of work in telecommunications at the FCC. We did file in this proceeding. Folks can go and to the FCC and see what we filed, and I'll say we filed in support of it with some cautions and some suggestions, but coming from the perspective that I think where Commissioner Carr started, we certainly have great concerns about disinformation on digital media, on media generally, traditional media and online digital media, and that the introduction of artificial intelligence really does pose a new threat to the transparency around the media that people are consuming, that it has the great potential to deceive people, and that nowhere is that more important than things that impact our democracy and our structures, our systems of democracy, like elections. If I were to make up things that are possible right now around issues that are politically controversial, and it would be a shame to see deep fakes or fake AI generated content. For example, people are have very serious and strong opinions about the January 6th insurrections. Imagine if someone on the left were to contrive using AI false accounts, video footage of protesters and what they said, or even of officials and what they said on that day. Conversely, just in the news today, you've got folks on the left concerned about what former President Trump is saying about the impact and the quality of the response to the hurricane that we had in the Southeast recently. Imagine how folks would feel if there were false accounts from people on the ground about whether or not they've been reached by FEMA and federal emergency officials to gin up displeasure with the current administration. I mean, these are the sorts of things that can have an impact on our democracy, and are reasons why it's important that there is transparency. And I would hope we can all agree that there should be transparency as best as we can to help folks trust the media that they're consuming and the content that they're consuming, without limiting the free speech and free expression of Americans to express their political views. I don't believe that these rules cross that line. And when it comes to authority, our filing argues that the FCC does have authority under Title III, the Communications Act, Section 303 and 315 and 317, where they were directed to do things like create the political file for all license holders of spectrum that Commissioner Carr referenced, but also to where they were empowered to mandate certain disclaimers on political advertising, and this was came out of the Bipartisan Campaign Reform Act, giving the FCC, naming the FCC, and giving them authority to create those sorts of disclosures on advertising. So I think the authority is there. I think this is a narrowly targeted effort, not that it is content neutral, that it does not prevent AI from being used at all. It simply requires that people know that AI is being used. And that's a good thing. We want people to continue to innovate and test out and try and use AI, hopefully for beneficial purposes, but not for deception. And certainly not for deception around issues important to public debate and our elections. I think this authority complements the Federal Election Commission, and as I said from the beginning, we focus on tech policy. I haven't really dealt with much of the Federal Election Commission. I look forward to hearing what Commissioner Smith has to say. But I think it complements the FEC's power. The FEC was asked over a year ago to weigh in strongly in dealing with deepfakes in election information, deepfakes from AI, back in July of 2023 from our friends at Public Citizen. They have not done much. They have put out some a statement that they'll look at things on a case-by-case basis, but no clear rules. And the FCC's limited authority that I mentioned that they have, I think, complements what the FEC could do in the long run as they continue to wrestle with these questions. In fact, the FCC, in some ways, can go a bit further than the FEC can, because the FCC is dealing with the public interest obligations on broadcasters. And that goes beyond just federal office election ads and can get at state ads and issue ads. And that's a good thing for someone like me who lives in the state of Virginia, longtime multi-generational Virginian, where we have elections every year. If the commissioner is right and these rules are not enacted before the November election of this year, getting them enacted quickly would be great for folks in the state of Virginia and other folks who have elections in 2025, so that there's greater trust and transparency around the content that people are being given over broadcast stations. So I'm sorry to say that it feels like this is getting politicized a bit. I know there was a bill introduced in Congress to stop the FCC from looking at and creating these sorts of rules. It hasn't gone anywhere yet, but it has been introduced. And simply saying, let's not do this, I think ignores the threat that we have coming from disinformation and artificial intelligence contributing to the speed and the scope and the quality of which different disinformation content can be created. There could be good faith arguments put forward about narrowing the definitions. I think you saw some of that, Commissioner Carr saw some of that in our filings. We suggested using the term content instead of information to try to make it specifically about what people are consuming and not the data that's being transmitted or anything like that. There could be good faith suggestions that, hey, let's finish this rulemaking, but it doesn't take effect until after November of 2024 because we're so close to election. I haven't heard anyone suggest that. But instead, we've seen a lot of folks say that they just outright oppose these transparency rules that help build trust for consumers of content. And I think they're missing the threat when they say that there should not be that level of transparency. I'll stop there. Happy to entertain more questions about the FCC and its authority and its history of adjusting as technology has changed the way that communications are received. I think there's a long history of the FCC doing that, and as the expert agency on communications networks, we encourage them to do that. But I think this is a good first step to the conversation, and one that I hope the FCC and the Federal Elections Commission and other agencies will engage with each other and use their different authorities but they're complementary authorities to protect our democracy and protect consumers from the vast swaths of content that are pushed out there. I'll add one more thing actually before I stop, Randy. I don't know if I have enough time, but I'll just say Commissioner Carr's point about I think he called it tech neutrality in his opposition when the proceeding started, that the FCC only has authority over broadcasters, I think is accurate. And we would welcome, again, I think a good faith argument. We would welcome folks who want to call for an expert agency to have regulatory authority over protecting the public interest on digital platforms. Public Knowledge wrote this back in 2019. I think, that would complement what the FCC has over communications networks, and those sorts of things can help update and build greater expertise in the government in a way that I think goes in the direction that the commissioner was pointing to, that media is not just broadcast video or broadcast radio, but is now streaming over the air, streaming over the internet, an area that to date the FCC does not have authority to deal with that over-the-air content at that level. So thank you for having me, and I look forward to the conversation.
Thank you, Chris. And the Federal Election Commission, of course, has already been invoked several times here as having some relevancy to what may legally possibly could be done, or if not even as a matter of law, what should be done because of the FEC's own jurisdiction. So we're and its own activities. So we're really fortunate to have with us one of the truly great living experts on federal election law, former FEC Chair Brad Smith. So Brad, why don't you bring the FEC into the conversation and whatever else you might want to say.
All right. Well, thank you, Randy. And I want to thank Commissioner Carr and Chris as well. It's nice to engage with everyone and those who are listening too. So I would agree at the outset that there can be some unique threats posed by deepfakes, that the visual imagery and voiceovers can be very emphatic, and people tend to believe something that they think they see. And there may be therefore some grounds here for modest regulation of disclaimers and so on. But I would note first that we shouldn't overstate the problem or think that AI is in some way totally new. I mean, already people are free to lie. They're free to lie about all kinds of things, what's going on the ground in North Carolina or any other thing. They can blame people. They can issue their spin. And we see that from presidential candidates in the debates saying things that you're kind of outraged about, people on both sides, and saying that's probably not right. Also in campaigns, of course, many of these things can be blocked. For example, we have prosecutions already going on where people have given incorrect information about where and how to vote with an attempt to prevent people from voting. We know that defamation laws can be used. So, for example, if you use deep fakes to defame somebody, you're covered by defamation laws. And so a lot of this, we shouldn't overstate the novelty of what's going on. It's a new technology, but it's applied to an age-old problem. Now, when it comes to that problem, I think it's pretty clear that this is something, this rulemaking really goes beyond the FCC's authority. And I'm going to indicate some reasons why. I mean, first, there's the basic formal approach. As then Judge Ginsburg, later Supreme Court Justice Ginsburg, wrote way back in the 1980s, quote, "The FEC is the exclusive administrative arbiter of questions concerning the name, identifications, and disclaimers of organizations soliciting political contributions." That's the FEC's bailiwick. I don't think the FCC has that power, and I don't think it can come from a broad general directive. For example, Section 303 basically just gives the FCC the authority to implement its authority, to issue rules on its authority. If it doesn't have that authority, that section doesn't help it at all. Section 315 is just a broad public interest requirement, but that public interest has never been construed as applying to regulating political advertising, which again is set up to be regulated by the FEC. So I don't think that you have a good grant of statutory authority. And this kind of thing creates problems that we need to be aware of. You get bad regulations. For example, this proposed regulation shows The FEC, let's put it this way, the FEC, or I'm sorry, the FCC does not have expertise in the area of political regulation. There is no sign in this rulemaking and its lengthy notice of any real familiarity with the numerous Supreme Court precedents that specifically govern campaign finance and govern disclosures in campaign finance and so on. That's just not much that's there. So, for example, we're left with knowing that this rule would regulate controversial issues. Controversial is something that, what's controversial to a person has almost no regulatory meaning. It talks about regulating political matters, but it doesn't say, is this the same definition as the FCC has used in the political file rules? Is this the regulations that the FEC uses? Is this something that the IRS uses? It talks about regulating issue ads. There's no real definition of issue advocacy in play in the political world. Issue advocacy for campaign finance purposes is simply defined as anything that is not express advocacy. And express advocacy is something that expressly advocates the election or defeat of a candidate, a fairly narrow category. So we have a lot of vague definitions here, and I think that shows what happens when you start to move things into a non-expert agency. It's also worth noting that the FEC is designed to handle some of the difficult problems that come up in this. For example, it's been mentioned that, maybe this is being politicized. It's been concerns about trying to rush the rule through before the election because one party feels behind. One of the key things about the FEC is the FEC is one of the few federal agencies that has an equal number of commissioners from each party, 3 and 3, and requires 4 votes to take action. This is a crucial point to try to protect our elections from one party simply taking over and trying to issue rules that are advantageous to that party. And it's interesting to see here, and we've seen this in the past as well, that when one party gets frustrated with the FEC's bipartisan makeup, they respond by trying to shift the action to another agency that doesn't really have that authority, that is not designed to handle regulation of political campaigns. It's not designed for it because it's not what it does. It's not what its lawyers know. It's not the field it works in, but it's also not designed that way because it is under partisan control. There is a partisan majority on the FCC, and you're naturally going to raise these kinds of suspicions if the FCC starts moving forward with an aggressive interpretation of its statutory authority. What are we going to do here, for example, if the FEC eventually issues different rules than the FCC does, which take precedent? Or will candidates have to live with both rules, taking up huge percentages of their ads with all these varieties of disclaimers, some required by the FCC, some required by the FEC? Maybe the Federal Reserve can get into the action since these ads are purchased with money and the Federal Reserve prints the money. We can't kind of use any kind of vague hook as an authority for an agency to take over. So I think that here it's very problematic. I don't think that the FCC's authority gives it the authority to regulate, quote, these sorts of rules. It gives it the authority to issue very specific rules on the political file and very specific rules on stand by your ad disclaimers, not anything else. Those were very specifically written into the statute. The general regulation, again, of political advertising and political campaigns falls to the FEC. I think I'll go ahead and leave it there so we can get on to a little crosstalk and some get some audience participation. I do want to say our comments, that is comments from an organization I had today called the Institute for Free Speech, are also available if one looks at the comment page on this rulemaking of the FCC. But the bottom line is, I would say that I think these rules are flawed in certain areas of concept, and I think part of the reason they're flawed is this is not what the FCC does. It's acting outside its expertise, and that's always a problem. And so it's not merely the formalistic complaint that it's acting beyond its authority. It's that has consequences for the quality of the rules and public trust in the rules as well. Thank you.
Thank you, Brad. So I think what I want to do now is go around again, but I took a look at the questions, and we actually have, I think, some good questions here. That's not to say that's not the norm at these teleforums, but I think these are especially good. And so what I'd like to do is just read these questions, then each one of you can take what you will and answer these as we go around again. But let's just put them on the table because I was going to ask a couple of these things. So the first one is actually directed to Commissioner Carr, but of course everyone will have a chance to answer. Can Commissioner Carr explain what he means by the FCC's choices here, quote, breathing new life, close quote, into older FCC rules and precedents? Aren't those rules on the books and in effect currently, whether or not there is an AI political ads rule? And then the next, so that's one. And then the second question goes to the proposed definition of AI. It says, does the proposed rule define AI for its purposes? And I did read the FCC's proposed definition at the outset, so I won't do that again, but I think it prompts, the question as to whether that's an effective definition or should be altered in some way, narrowed or what have you. And then the third question that we have presently, and by the way, the audience can keep them coming, these are good questions, is it the government's role to build trust? That's in quotes, in political statements, ads. Perhaps it is more efficacious to, quote, build cynicism, close quote, so that the public are smarter consumers of information. It seems to be a romantic delusion to try to create a sanitary bubble of accurate communications just so the public can be lazy and credulous. So I'm going to leave those three questions on the table, and let's just go in the same order and take those or whatever you'd like to say. And maybe this time try to, in your minds, limit the responses to, say, 4 or 5 minutes so we can go around again. Brendan, go ahead.
Yeah, thanks. I'll take that first question you asked about what I mean by breathing new life into these old precedents. I mean, two things in particular. One, if you look at footnote, I believe it's 6 of the NPRM, where it cites back to these 1960s era statements, it goes in and says, yeah, we know that in the 1980s, the FCC eliminated some of this, but we don't want people to overread that. There's still this underlying sort of FCC role and authority to police content on broadcast. So it's breathing new life into it by, at least for the first time I'm aware, sort of narrowing or purporting to narrow a 1980 decision that I think had broadly been read as, closing the door to this idea that the FCC would be the speech police. And then just two, I mean it in sort of a broad sense where, those cases, even if that door hadn't been closed in the 80s, has not been used or relied on by the FCC. And I think if you'd ask most people, can the FCC pull a broadcast license for airing, misleading information? I think most people would tell you, either no, or they haven't seen the FCC do that in a very long time. But here the FCC is very clearly saying, at least the Democrat majority, yeah, that's the FCC's job and we're re-upping it right now. And I think that's a very significant, if not underreported element of what this decision does. Again, you can talk about disclosure and transparency and minimalist, and I get that. But that source of authority that the FCC is pulling from is a very, very sweeping claim that I think, maybe should be more reported on. I do think, one of the things that Commissioner Smith said that is important is that, where Congress has given, more than sort of pinprick authority over core political speech, it's done so in the context, as he noted, of a 3-3 commission. And I think that's very important. The FCC has some stuff to do, as we all have talked about, but they're sort of isolated one-off things. If you're going to talk about sweeping regulation of core political speech, which again, reasonable people may disagree, but I think that's what this is. Congress has only done that in the context of a structural protection to make sure that it happens when the agency has to be bipartisan in it. And finally, in terms of the broader sort of politicization, got to get better at that point. I do think that there is a broader debate that at least I see this fitting within, whether the authors of the proposal intended it or not. There's a broader debate going on right now about should we have more government control, more government checks on speech generally, whether it's online speech or otherwise, or not. It's a very live debate. I mean, former Senator, Secretary of State Hillary Clinton had some remarks over the weekend that were reported about at least this suggestion of wanting more government control over online speech. John Kerry recently had very similar remarks, I thought. And we are seeing a global trend. I think Brazil is part of it as well. And I've spoken on that issue where there's a lot of efforts right now to crack down on free speech on the internet. And I think it's a 180 for a lot of these same officials that were previously extolling, the virtues of free speech on the internet, how it's key to a healthy democracy. Now we see a lot of rhetoric, from my own view, I think coming more from the left, about free speech being a threat to democracy. So I do think there is a broader debate right now on the future of free speech. We're generalizing. I think conservatives are more pulling on the free speech, less regulation side. I think the left is pulling more on the more regulation side. And so I think if that's a construct that you have, I think you could view this as, falling on the more regulation of political speech side and sort of concerning from that broader, whether you want to call it political or policy debate. I think you can view this as sort of fitting within that. But others disagree, and that's fair as well. So yeah, but happy to turn it on. Turn to the next person.
So Chris, I'm going to turn it to you, but in the meantime, there was just one more question. Maybe you can address this, because and that goes to the definitional issue about AI. And I think you said in your initial remarks that you thought that perhaps it needed to be narrowed. I'm not sure I have that right, but there were commenters on all sides of this question that had problems with it. And I think this questioner sort of puts a point on it when he says almost all media today is digital, which by definition means algorithmic. Software is used in its production. Some may work automatically, such as focus or brightness. Thus, AI could involve anything from straightforward creation of the media or minor adjustments to complete fabrications, which, as stated, aren't necessarily new. How could the panelists define AI to make such a disclosure rule workable? Do you think it's possible, based on what we know about AI now and the way it's evolving, to even fashion a workable rule?
It's a smart question, Randy. And I think we should aspire to, and there may be different categories of it. I certainly would argue there are different categories of AI, from the generative AI that has gotten, that's the chat GPTs and the large language models that folks have gotten excited about in the last couple of years, versus stuff that, would be categorized by some folks as AI that has been a part of online media for many years. So I think defining it is important. I think in our filing, we pointed towards the work that NIST is doing to try to right now to put smart definitions on artificial intelligence and to try to create some alignment across agencies using the expertise at NIST on that. So I think the definition is important so that it's as narrow as possible around the threat that we have with the rule that the FCC is trying to make here. And let's be very clear about the facts of this rule. Because yes, there's great concern about disinformation online. This rule does not touch online content that the Commissioner Carr was talking about. This rule only touches content coming over broadcast. Why? Because the narrow authority of the FCC with this rule and Section 317, which the Commissioner Smith did not mention when he was talking about authority at the FCC, but gives the FCC authority to give these sorts of disclaimers and comes, out of the actual statute, the Bipartisan Campaign Reform Act, that names the FCC. So it does give Congress gave it specific authority to provide the sort of clarity to folks about the advertising that it's getting through the broadcasters. Why broadcasters? The history of the FCC is clear that the public airwaves are limited. They're a limited resource. And when broadcasters receive a license, and for many years they receive them for free, now they auction them off and make a little money for the government to fund other projects. But when they receive that limited resource of electromagnetic spectrum to broadcast, there are obligations that come with it. this is why the rules that may be old, but Commissioner Carr doesn't like about enforcing a level of regulation on broadcasters and whether or not they're misleading the public are there. And this rule does not get at what he's describing. This rule only gets at providing transparency and disclosures about AI being used in these ads. It does not threaten to take away a license from a broadcaster. It simply requires that they provide that level of transparency and disclosure. So I think they are not sweeping regulations. I think they're limited, and they point in a very good direction. The comments that Commissioner Carr pointed to coming from Hillary Clinton on the left, calling for, regulations, repeal of like Section 230 regulations, things like that, to force digital platforms to moderate more, I think is misguided. I'm a big defender of Section 230. I think it is what allows the public entities that are running digital platforms on the internet to moderate content. Because it does not chill their ability to enact moderation, and that the marketplace, if we had greater competition on the infinite channels of the internet, the marketplace could allow people to go to the platforms that moderate more, moderate less, depending on which they would prefer, whether you're talking about social media, whether you're talking about even some of the discrimination we see in other digital platforms like online marketplaces. So this rule doesn't deal with the internet, deals with the limited scope of broadcasts that the FCC has, which has always had public interest obligations put on it because it is the public's airwaves, and it would not revoke licenses because of disinformation that is found in these ads. It simply would label it so the public can choose for themselves. And to the point of one of the questioners, yes, create greater skepticism by providing that information to the public. So maybe I misspoke. I think the questioner was right. The cynicism and skepticism that comes by informing the public is a good thing. I kind of flipped it on the positive of saying providing trust, but I think that's a fair way of thinking about it.
Thank you, Chris. I hope broadcasters and whatever can get the future FCC chairs and commissioners to rely on your statement that they will never revoke a license for violating this rule.
I just meant this rule does not.
Let me. I want to just. I don't even know whether this probably anyone could answer shortly, and then I'm going to turn to Brad in a minute. But one of the things that relates to the definition, to the extent it may be problematical by being all-encompassing, in other words, very broad, is that I know Commissioner Carr and I think Commissioner Symington in their dissents, I believe both made the point that what may happen, in fact, is that almost every ad, that is political will be required to have a definition because of the things that are done to use, current algorithms and so forth. And if that's true, that it would become something that people would not pay attention to or be turned off by, and sort of become like the drug ads. So it does seem like that might be a dimension that somehow needs to be addressed. But I want to turn to Brad to make sure I get him in. And Brad, I want to just read something the commissioner said in his notice and have you respond to that. And I was triggered on this when you mentioned your free speech, the work that you've always done in the First Amendment area and free speech, and get your reaction. The notice states, and actually a couple of places in almost these same words, quote, "The proposed on-air disclosure and political file rules would further the goals of the First Amendment and Communications Act by ensuring broadcasters and other regulated entities take reasonable measures to address potentially false, misleading, so forth, deceptive ads, thus promoting an informed electorate and improving the quality of public discourse." But just specifically, are there First Amendment concerns that you have in terms of, from your perspective of protecting free speech that differ from the FCC's cast that it puts on it here? You're muted, I think, Brad.
Sure. Thanks, Randy. Yeah, there absolutely are First Amendment concerns. I start with the basic concept in that statement that you quoted from the rulemaking. So I've always said, when somebody says we're furthering First Amendment goals, I'm always very concerned that they're therefore violating the First Amendment. The First Amendment is not just about goals. It doesn't say the government shall take steps to ensure that there's a vibrant market for free speech or something. It has a very specific way that this is done. The government doesn't make laws in this area. Now, we agree, I think, that there are certain exceptions to that. One might be, as I mentioned earlier, defamation, and there can be a few others. It is true you shouldn't falsely shout and intentionally falsely shout fire in a crowded theater to create a panic. But generally, there has to at least, I think, be a supposition, a presumption that the government cannot act to try to increase the caliber of debate or something like that. That's not the government's role, and that's the recipe for the government to go into favoring one side or the other under the theory that, oh no, we're just trying to enhance the debate and make it better. These are also very specifically raised problems for the First Amendment. Disclaimers are a form of forced speech, and generally the government can't coerce you and force you to speak. And at times they can start to take up far too much of an ad. So for example, this proposal has certain minimum typeface for how big disclaimers need to be on these ads. And that kind of large, you start to put those kinds of things into disclosure rules, they can take up a huge portion of the ad. People say, how much does it take to say this is generated with artificial AI? Or, I'm Joe Blow and I approve this message, one we've had for a long time that nobody pays attention to. We have those rules. How much do they take? Well, they don't take very much. They take a couple seconds of an ad. You can say a lot of good stuff in those couple seconds. Give me liberty or give me death. I won't raise your damn taxes. You can say a lot of good stuff that's much more valuable to lawyers, to voters, to lawyers probably too, to voters than these formulaic ad disclaimers. So I think we need to be very careful in those. I do think Chris respectively or asked me about specifically about section 317, and respectfully, I disagree that it allows the FCC to write these sorts of rules. 317 is very specific about just saying that it was a paid political advertisement. It doesn't provide broad authority. And that goes with the question, why doesn't the FCC, why can't they reach the internet with these sort of things? Well, because they're not the political regulatory agency. The FCC, or I'm sorry, the FEC, it gets tough to keep these agencies straight, the FEC can issue those broader rules, and that's the agency that Congress wanted to do it. And again, that bipartisanship is important. Something Commissioner Carr said in his opening remarks, he noted that the way complaints can be used for a very partisan basis. And it also goes to the very nature of a rule. I've often said, if you tell me you want a content neutral rule, because we have to be content neutral, but tell me whose ox you want to gore, and I will write you a content neutral rule that gores that party more than the parties opposing them, because different campaigners use different types of techniques. They appeal to different audiences. They do things differently. And so it's not that hard to write content neutral ideas that are not content neutral, and just take it out of the context of this debate. People have said for years, right? A law that prohibits sleeping under bridges doesn't affect rich people very much. It affects poor people, but it's certainly a neutral law as to sleeping under bridges. Same kind of thing with content requirements for political ads. So I do agree with our listener who worried about trying too hard to build trust rather than build cynicism. Our country was built around a certain amount of cynicism. I think we need to be careful about limiting anything here to sort of the objectively false portrayal of people's statements. And again, I would note there's nothing illegal about having a person, an impersonator, get up and impersonate a politician's voice. The question is merely then, are they saying something objectively false that violates the law or that is defamatory? And I'm not really sure we want to go much beyond that for the barrel of I don't know, what is it? Something of worms that it will open up. And I think for that reason, we should be very careful here, take plenty of time and leave it to the agency that's designed to do this. That's the FEC.
Okay, let's do this. We have literally just about 3 minutes before I think we should wind it up. So I want to give Brad just spoke. Let's give Brendan Carr and Chris Lewis a final word. But just if each of you would just take a minute, then I'll be able to say a proper thank you and goodbye. So Brendan, why don't you do that first, and then Chris.
I'll make maybe one macro point that hopefully hits home to any of the lawyers that are listening, which goes to the Supreme Court's recent decision in Loper-Bright. This is an issue, regulation of AI or regulation of AI in the context of political speech. That clearly is an important issue. People feel very passionately on both sides of it. So maybe the better question should, not be, whether the government should do anything, but which component of the government is the right one for this debate to be taking place. And I think Loper-Bright would tell us, and frankly, I think the Constitution would tell us, that it's the people's elected representatives in Congress that should decide whether or not to regulate political speech. I think there's been some legislation introduced to block the FCC's effort from moving forward. I think that's the place for it. Now, some people say, well, we can't rely on Congress. They don't get anything done, which I would say, well, that's, maybe a feature, not a bug of the constitutional system. The people have elected a Republican House, a Democrat Senate, and that makes it difficult to pass things. That's the will of the people. And so I think maybe there's a broader point here about trying to rehome these decisions back into the legislative branch that would probably hold us in better stead than where we are. And again, some people say Congress is dysfunctional. Maybe if we didn't have these escape hatches of 3-2 agencies that could pass laws, maybe Congress would find more common ground to compromise and get stuff done.
Thank you, Brendan. Chris, just take 1 minute and you can have the last word.
Sure. Yeah. Let's see. Where do I start? There's so much to argue back against, but I'd say that this rule is, if we don't have these rules, it's a question of then what are we going to do to create the cynicism that the questioner asked about. 317 Communications Act, or put into the Communications Act, gives the FCC the authority to give the transparent disclosures about who paid for ads and et cetera. Imagine if generative AI, again, we're not talking about impersonations, we're talking about people who are trying to make something look like it's real. Imagine if generative AI created an ad that said someone paid for it, but they actually didn't pay for it. This update to 317's rules from the FCC gets at that threat to our democratic processes and our political ads. So I think it's a smart extension of the transparency, again, not limiting what people can say, but saying, when I say it, I used AI to do it, is incredibly important. And that just one example, I think, shows us why these rules are important. If we don't have these rules, it is critically important that those who are critical of them come up with solutions to solve this threat that we have from the scope and the quality of disinformation that can be created by AI.
Well, look, I thought myself, this was a really terrific discussion. The panelists each were terrific, and one way of further judging that is it evoked very intelligent questions. I thought, not even artificially intelligent questions, very intelligent questions. So I just want to conclude by, I'll thank the audience members for listening and for their questions. And of course, I want to thank Brendan Carr and Chris Lewis and Brad Smith for a very useful, informative, interesting discussion. So with that, I'll turn it back over to Caroline.
Great. Well, thanks, Randy. And on behalf of the Federalist Society, I want to thank our speakers for the benefit of their time and expertise today. Thank you also to the audience members who joined us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in. And with that, we are adjourned.